Chapter 20, Transfer of Title. This chapter, we're going to describe 4 methods of title transfer, explain the process of transfer of title of a deceased person's property. The word title in real estate, I've told you guys before, simply means ownership. There's no document in real estate called title. So title of real estate is ownership of the land. And alienation, transfer of title to a parcel of real estate. It could be voluntary, it could be involuntary. It could be while you're alive, or it can be after your death. So let's just highlight title to real estate means the right to or ownership of the land. And we're going to write in here alienation, the transfer of title to a parcel of real estate. And then they got it here that it can be transferred during your lifetime, either voluntarily or involuntarily, and at death, either voluntarily through a will or involuntarily if no will is left. What do we call it if you die with a will? Anybody know?
Testate.
Testate. And if you die without a will?
Intestate.
Intestate. There you go. So you already added some of the things we need to get to now. So voluntary alienation can be done by gift, sale, or exchange of the real estate. Owners use some form of deed to convey that ownership during their lifetime. You know, because a deed is only valid while you're alive. After your death, your ownership transfers voluntarily upon whatever your will says. You know, whatever, or by will to transfer voluntarily upon their death. Okay, so by a will. Transfer of ownership to or from the government is, well, dedication is when you give land to the government for a public use. It doesn't mean you leave it when you die. You could be alive and give land to the government. You know, you do a subdivision, you give them the street, so it becomes a public street, right? Not one that you need to maintain. So dedication is when you give that land to the government for a public use like streets, schools, and parks. And public grant, you grant your ownership. So when the public grant ownership, they grant it to an individual, right? So when government gives public land to an individual for private use, it's public that's granting it. So public grant. I don't think you'll see that one exam. This one, yeah, dedication. So voluntary alienation, let's do the highlights now. To transfer title voluntarily, alienation during their lifetime, you got to use some form of deed. Ownership of subdivided lands earmarked for streets, roads, or municipalities can be dedicated to the municipality. And lands owned by government may be transferred to individuals through public grant. Title to property can be transferred by involuntary alienation without the owner's consent. And when a person dies intestate without a will and leaves no heirs, the title to their real estate passes to the state by escheat. They escheat you out of your property. Well, in this chapter, we're going to learn what escheat, how that process of escheat actually works. Everybody had that, right? Or do I got to go back? Everybody good? Everybody good? Okay. So involuntary alienation is without the owner's consent. And if you die without a will and no heirs can be located, it can revert to escheat. Eminent domain is when the government takes your property. That's involuntary. You don't pay your debts, your taxes, or mortgage loan, you get foreclosed on. That's involuntarily transfer of ownership, right? Through adverse possession, when somebody's been squatting on your property and using it for a long enough period of time, they could claim ownership. That's involuntarily a way for you to lose your property. or by Mother Nature through the process of erosion, right? It's a decrease in land caused by the wearing away of land by wind and water. And a partition proceeding is if we are co-owners in a property together, I want to sell and I can't find anyone to sell my interest to, and you're not willing to buy me out, or you don't have the money to buy me out. Am I stuck owning the property here in New Jersey, or can I leave the state and sell? Well, I could take you to court, sorry, but I got no other option. I got to take you to court and force you to sell the property. So we'll take you to court through what's known as a partition proceeding, where a judge will examine the property to see if it can be physically partitioned and separated into pieces and deeded separately. Otherwise, the property will be ordered sold, and each of the owners would be given their shares of the profits from that sale. That's a partition. Everybody got partition there? That's second paragraph. Top
Yeah,
page.
I got it.
Now, when a person dies, you see this on page 374. When a person dies intestate and they have no heirs, the property would escheat to the state. These are all forms of involuntary alienation. If land is needed for a public use, it can be taken through eminent domain by a public agency or governmental agency that needs it. But the owner will be justly compensated. If you don't pay your debts, foreclosure is the process of that lien holder taking it. That they could then sell and get some of their money back through the sheriff's sale, sold to the highest bidder. Or through open, notorious, continuous, hostile, and adverse use of another person's property for a long enough period of time. Through adversely possessing it, an easement by prescription can be claimed. Using a suit for adverse possession, it would be claimed by the adverse possessor who's been squatting on your property all that time. We went over that in chapter 7, but we'll go over it a little bit more and have some more highlights right here. We already went over this one. You highlighted this, the partition proceeding, where one co-owner forces another to sell or divide that property. So I don't know why it's here again, but either way. Easement by prescription through adverse possession. In chapter 6, we went over this. Some people call it squatter's rights. It's when somebody's been adversely possessing your property for a long enough period of time as prescribed by state law. They could claim ownership of the property. However, the taking is not automatic. It has to be perfected. An easement by prescription has to be perfected in a court of law. Currently, nobody's going to win an adverse possession suit in New Jersey. Why? Because our politicians made too many laws covering the same topic. You know, they love to make laws and say, I did this, I did that. Hey, did you check the books? There was already a law on that. Now you just created a problem. You created a conflict in the law. So that ended up happening about 15 years ago. They created that, well, longer than that, but 15 years ago is about the time where I started tracking where there was a court case where one party, it's actually two commercial companies, one sued another trying to take the property through adverse possession because they had it fenced up around the property and they've been using it for a period of time as defined by state law. But then it was brought up the fact that, well, even though you've been using the property for a long enough period of time as defined by state law, there's another law in the books, a common law of 20 years that says you need to bring the case to court within 20 years. Well, we couldn't bring the case to court after 20 years because there's a state law that says we need to have used it for at least, I think it was 60 years because it was unimproved. And they did use it. They've been using it for 60 years. So they tried suing. The judge did not rule on the case. Oddly enough, judges often like to wield their power, but they're not supposed to, because what is a judge's job? A judge's job is to interpret the law and make decisions based on established law, right? They're not supposed to what we call legislating from the bench. That's basically creating laws by their rulings that they make. If there's no law covering a topic, they're supposed to throw it to the politicians to then write one, or correct it if there's conflicts. This judge, he did the right thing. He or she did the right thing. They kicked it out of court because there was a conflict in the laws. Too many rules covering the same thing. So our politicians in New Jersey legislated back and forth, and they know exactly what they want to do to change the law. They're going to do away with this 30-year period for improved lands that you had to use the property for, or 60 years for unimproved lands, in favor of the 20-year common law. However, it's been almost 15 years now that they were in agreement on that, and they still haven't voted on it to pass it. It's still sitting there on the New Jersey legislature's rules of proposed changes. Now, if they want to pass a new gas tax, how long does it take them to do that? Right? Was it 30 days they pass a new gas tax? But to fix some of the problems they created, even though they're all in agreement on what they want to do, 15 years later, we're still waiting for them to vote on it. Why don't we vote these people out of freaking office? Why do we keep voting for the same idiots who do nothing? Anyway, so to perfect this type of an easement, by prescription, it requires a court action called a suit for adverse possession to claim the ownership of the land. Now, that use must have been continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use must be visible, open, and notorious. It can't be like, I've been using the property for the last so many years. I got an underground doggy fence buried around the perimeter of the property. No, it has to be out in the open. It has to be obvious and visible, open, and notorious that you've been using the property. It can't be like, I've been using it in secret, So that prescriptive period for improved lands is 30 years. So if there's a structure on the property or there's any man-made improvement, there's pipes, there's a road paved, those are man-made improvements, then it's 30 years. 60 years for unimproved woodlands are required. Now, through the process of tacking, successors in interest who may not have been there for the entire period of time as required by law can still file a claim of adverse possession and tack on one person's time to that of another to reach the prescriptive period. Okay, they call that tacking. Now, you could always prevent somebody from claiming adverse possession or successfully getting an easement by prescription granted to claim the ownership by taking legal action against the adverse possessor to get them removed from the property, by cutting off their access so it's not continued for all that time, and this resets the time clock, or by giving them permission. You can't claim an easement by prescription if the owner gave you permission to use their land. It has to be, one of the conditions are, let's see, what is it again? Continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use must be visible, open, and notorious. So you can't claim an easement by prescription if the owner didn't give you permission, if they gave you permission to be there. And here's an interesting little note, important to know though. You can't claim easement by prescription against publicly owned lands, only against privately owned lands. So here's what we would highlight in this chapter, page 375. Interesting thing here. Once somebody does, if they're able to successfully establish title through adverse possession, the previous owner has no further recourse. You lost your property. You should have taken actions to protect it while it was in your possession. Um, if you own land, you should walk the boundaries of that land at least once every 30 years and take action against anybody who's there that should not be, right? Get them removed from your property. If you don't walk the boundaries of your own property at least once every 30 years to see if somebody's using it that shouldn't be there, you probably deserve to lose it, you know? Um, so once adverse user has established title, the former owner has no recourse. To prevent such loss of title, a person should, take action against any adverse possessor and walk that property at least once every 30 years. Now, here's an interesting thing here. I actually used this bit of information about a year or two ago, giving some advice to a mayor of a town in Metuchen. Property owners who feel that new governmental requirements have taken away the rights to use and or develop a property may seek damages under the concept of something called inverse condemnation. It's not going to be on exams, but it's good to know to lock away up here, if the government, what is this basically? If the government has created so many laws and regulations restricting on you on how you could use your own property, they basically render your property useless. So they devalued your property and you got nothing in exchange for it. You could actually sue the government, but it's up to you to prove it. You could sue the government that they've taken your rights away without compensating you for it. So it's called inverse condemnation when that occurs. And we had this. I was listening to a speech from this mayor, and he was talking about how you got somebody that has this one old lady owns all this land in town, and she it's used for commercial purposes. They got all these Victorian style buildings in the middle in the heart of Metuchen, and they were talking about how they were trying to force her hand to improve them, to upgrade them, to tear down what's there and put in new stuff and everything. But yet she maintains all the properties there perfectly fine. She's got every now and then, when need be, she'll tear down a building and then rebuild. She's been taking care of her property and all the land. She just owns a lot of it right there in the heart of town. So got a lot of pull, but they're trying to take it away from her as she gets older. And I said, you better be careful. I was like, you're trampling all over this lady's rights if you do this. Well, we need to do improvements and we need to. I was like, what do you mean you need to? This is her property. She could do whatever the hell she wants with it. Like, well, why would you? What business is it of yours? You're the mayor of town. You're supposed to, look after the interest of your constituents. This is her property. You're trying to force her to make certain changes because you don't like them, or you want her to upgrade and modernize to make more housing or whatever. What if she don't want to do that? She's got it as commercial properties right now. Why don't you go after some of the other industry in your town and get them to tear down their buildings and put up an apartment building? You want to collect more taxes or whatever the hell it is you want to do. I was like, you better be careful because she could sue you for something that's called inverse condemnation. And he's like, yeah, the city attorney just spoke to me about something about that. And I was like, yeah, it's real. You're basically, if you try to force the hand and not allow her to do something on her own property because you're trying to, take advantage of that, um, you're basically taking away her rights without compensating her for it. She could sue you for it and win. Anyway, that's that on that. So it does happen. And back in chapter 6, you guys highlighted all this stuff, so you don't got to go back there now. It's basically the same stuff that's over here in this chapter, just maybe worded a little differently. Uh, because back in that chapter, they wrote New Jersey law is silent as to the required number of years, although court cases appear to support a minimum of 30 uh, years of adverse use and 60 if it's considered woodlands. Okay. Well, obviously the person who was writing this or updating this does not know about that conflict in the law in New Jersey right now, and they're waiting for the legislation to be ironed out or do something with it. So they're gonna do away with the 30 and 60 years, and they're going to go with the 20-year common law. All right, don't need to harp on this anymore. So transfer of a deceased person's property cannot be done by title. A transfer of title through deed, because title just means ownership. Deed is the document that transfers that title. When does the transfer of ownership take place, though? Upon delivery and acceptance of the deed itself. If the person dies, how are they going to deliver the deed to someone else to accept it? You know, so upon the person's death, the transfer of title happens by will. And I know a couple of years back, there was a case where there was some Motown diva where she was planning on selling her house. And she actually signed the deed and put it in the FedEx delivering it. Uh, this was all done over the phone between her attorney and someone else's attorney, and they were on the line. And so the buyer and seller were on the line, and both of their attorneys were on the phone. And then they sent her the documents that she needed to sign. She signed the documents. She had them notarized, and then she was going to mail them through FedEx. But on her way to the FedEx, she dropped dead. Didn't deliver it. So now what happens? The guy, he already wired the money to her. She was just, all she had to do was mail the documents back. And then the house was his. Well, she died, and her kids, they didn't want to give up the house. They said the deed wasn't delivered, so therefore there was no transfer of ownership. Is that right? Is that correct? There's no transfer of ownership because she didn't deliver the deed during her lifetime? Yeah, that is. It's correct. So they were like, yeah. And we got all the money she got in the bank too, which, by the way, was wired. A lot of extra money was in that bank account recently because it was wired there by the guy who was purchasing the property. Kids can't keep the money and the property. They can't have their cake and eat it too. Greedy, greedy, greedy. So this was fought out, I guess, in court, and it was determined that there was implied delivery and acceptance because they were over the phone. Everybody was over the phone together. We had both the buyer, the seller, and both sides' attorneys, and everybody agreed that that was the intent of the parties. And she even had the contracts that were signed and notarized and in the FedEx envelope. She just dropped dead before she could deliver it. drop it off at the FedEx office, and so the kids, it was up to the kids. You either keep the money or you either keep the money and lose the house, or you keep the house and you don't get the money. Which one is it? Um, Implied delivery and acceptance did occur in the eyes of the court right there. All right, so that's just an interesting, oddball, weird case, but either way. So transfer of title by will is known as devise. Devise, you should not mix up with demise. Demise sounds like death, but it's not. Demise is a transfer of property by lease, whereas devise is a transfer of property by will upon death in your last will. So the devisor is the person who is leaving you the property in a will. Devisee is the one named in a will to receive the property. Testate, it means that you prepared a will, this, directing how your assets are going to be disposed of upon your death. So transfer of title by descent takes effect only when you die. Every state has their own laws of descent and distribution specifying who can inherit your assets upon your death, which that would only be your natural blood relatives or adopted children, um, when you die, intestate. Now, there are certain rules in place that if you have adopted children who are not your blood relatives, that they can inherit from their adopted parents, but not from ancestors of the adopted parents. Okay. It's kind of like Game of Thrones type thing, you don't have a right to lay claim to the throne. You're not the true blood, or whatever like that, that kind of that kind of a history, bloodline history that they're looking at right there. And if you see a lot of these older laws, they're written this way too, that it sounds very medieval. Um, okay, so intestate means you did not prepare a will. Testate means you did. Uh, Intestate is involuntary because you didn't decide who gets your stuff. Only people making claims for it. Okay, so always consult your attorney about making a will and your options there. But let's highlight intestate means having without leaving a will. Testate means you prepared a will. And all wills must be probated. What does that mean? Probate is a court proceeding that when somebody dies, it confirms who the people are identified who were named in a will, that who they are, say they are, is accurate. And any heirs confirms that they are the heirs. And all debts must be paid before anything is paid out to any heirs or people named in a will. Two things in life, certain in life, death and taxes. We're all going to die, and we all got to pay our taxes. We all got to pay our taxes even after we die. And if you did not pay them, well, they must come out of your estate before your heirs will get anything. So the will must be probated. Kind of important. Meaning that all debts must be paid, especially any unpaid taxes or claims from any creditors that claim that you owed them money still. That's what probate is. Probate, or administration, is the legal process where a court determines who inherits the property of a deceased person and what those assets are after all debts have been paid. Now, either an executor, that's a man, or an executrix, that's a female, named in the will. An executor is somebody that you name in the will to make somebody that you trust, you trust, maybe it's your best friend or family member, that you name in a will to make sure that all your final wishes are carried out and everybody who you wanted to get your stuff gets your stuff. So an executor is that trusted person who's a man that you name in a will to do that. An executrix is if that trusted person is a female that you named in the will to do that. Yes, these are gendered terms. It's Latin. So executors for a man, executrix is a female named in a will. Or if you did not name an executor or an executrix, the court will name somebody to handle that. If you got a brother or sister and they want to do the job, the court may appoint them. Otherwise, they'll appoint a lawyer to handle that job for 10% of the estate's value, of course, whatever they get paid something. So an administrator named by the court, if no executor or executrix was named and there was no valid will, would oversee the administration and distribution of your estate. So once again, here are these players. I showed you this in chapter 5 slideshow too, but here, an heir. What is an heir? Did you guys ever snap a picture of this when you guys were in chapter 5 of this slide? This slide shows you, it's a list I put together of all the players and what these things are. An heir is a natural blood relative who can inherit belongings of a relative who had died. They're your blood relatives. A devise is to transfer or leave property by will upon death. Your last will and testament. The devisor is the person who leaves their belongings to someone in a will. It's the person who died. And the devisee is the one who's named in the will to get your stuff. Demise is a transfer of property by lease. I just throw it here because I don't want you to confuse it with devise. Testate means you made a will. Intestate means you did not. Testator is a man. Testatrix is a female who makes a will. Probate is a court proceeding that determines who the natural heirs are, or to inform or to confirm who the devisees of an estate are, the people you named in a will to get your stuff. No matter if you had a will or not, what the assets are after all debts have been paid. Now, if you don't have a will, you won't have any devisees, because a devisee is someone you name in a will to get your stuff. An executor is a man. Executrix is a woman, a female. Is a trusted person you name in a will to ensure your final wishes are carried out as outlined in the last will and testament on how to distribute your assets. If you did not name an executor or executrix, the court will appoint an administrator to take care of those duties. Descent and distribution is the law that determines who your natural heirs are that can lay claim to your estates, to your throne. Escheats is when you die intestate and no heirs can be located, the property will revert to the state. So the property is sold at auction and the money is held in a fund for 1 year, in which time your heirs can lay claim to it. But if nobody steps forward to claim it, the state gets your money. We're going to go over how that process exactly works in a moment. A legacy is your personal property that you've amassed during your lifetime. All of your jewels and your clothing and your cars and such, all your personal property. That's your legacy. And you could bequeath it to anyone you want. That's your wishes on who you wish to get it. If you wrote a will, you could bequeath it to someone. Bequeath it. Dower and courtesy rights. Dower, because dower begins with a doe, and a doe is a deer, a female deer. That's the wife's right in all of her husband's property upon his death. Courtesy, because men should be courteous to women, that's the man's right in the wife's property for all the property that she owned during her lifetime. Now, Dower and courtesy rights were abolished in New Jersey on May 28th, 1980. A date you need to know. So you need to know which is the wife's right, which is the husband's right, and what day New Jersey abolished the creation of any new dower or courtesy rights. They didn't abolish dower and courtesy rights, they just abolished the creation of any new ones. So anyone that was married before May 28th, 1980, they still have dower and courtesy rights in all of their spouse's assets that they owned upon their death. Marriages after this date, your spouse only has interest in the primary marital residence. And any other property you could have left to your girlfriend or whatever. Made a joke there. So you can leave it to whoever you want. Your spouse only has a right to the primary marital residence. However, there are laws in New Jersey that your spouse is entitled, there's minimums that you have to leave them in the will. Yes. All right. Here's a couple of government run websites for you guys: missingmoney.com, unclaimedproperty.nj.gov. New Jersey no longer participates in missingmoney.com. We used to, but you could still find some things from New Jersey in there. New Jersey now has their own unclaimed property page you could go to here. And I suggest, no matter how young you are, look up your name in there. Look up your parents. Look up your other relatives. You maybe do something. I once had a girl who was in her 20s in my class, a young girl. She looked up her name and she found a couple $100 that was due to her because she used to work at one of the stores in the mall, and the boss never paid her her last check. Instead, he turned her over to the state. I guess he was just being a jerk. It's not like he didn't know where she was, or she didn't move or anything. So she's like, yeah, it ended up being my last check that my boss owed me. They turned it over to the state instead of giving it to me. I'm like, oh, look at that, missing money, right? So that's when it was in missingmoney.com. Now it's unclaimedproperty.nj.gov. Okay. But either way, check them both for your names, your relatives' names. You may find something. It didn't have to be necessarily that someone died. My dad, when he was still alive, um, I looked him up and I found that he was owed several $1,000s. We were able to find it. He bought a couple of savings CDs, and those savings CDs matured, and he never cashed them out because they matured. But that branch of that bank that was like a couple blocks from our house, the bank sold to it, was taken over by another bank, and they actually tore down that physical office over there. So it wasn't even there no more. So out of sight, out of mind. So he totally forgot about it. He still had to wait a couple of years for it to mature. And then when it did, I found out that they turned it over to the state. Different things are stayed with different with the state for different periods of time. Banking stuff was with them for like 10 years. If it's your estate because you die, your house, that's 1 year, it stays in the fund. So anyway, these are a bunch of resources that I put together here for you. Check it, because every class I've had, there's always been at least one person that found something. And I only ask for a moderate 10% finder's fee. No, I'm just kidding. All right. So a last will and testament is an instrument made by an owner to voluntarily convey title to the property after their death. And a party who makes a will is a testator or testatrix if they're a female. And the gift of real property by will is known as devise. In New Jersey, children can be disinherited, so be good to your parents. Well, you should be good to your parents, not for that reason, but be good to your parents. But a surviving spouse is entitled to at least 1/3 of the estate. So your parents can write you out of the will, but they can't write their spouse out of the will. they're entitled to at least 1/3 of the estate. And the determination of that augmented estate is a complex calculation. In a case where a will does not provide the minimum statutory inheritance because your spouse did not leave you the minimum that was required by law, your spouse has the option of informing the court that you're going to take the statutory share rather than the lesser share that was left to you in a will. This is known as the right of election, and that is reserved only for surviving spouses. So your spouse can't write you out of the will. They have to leave you something you're entitled to, at least 1/3 of the estate. Now, a will differs from the deed in that a deed conveys your interest while you're alive, and a will only does after you die. So to be valid, a deed must be delivered during the lifetime of the grantor. You really should highlight that. And here's from chapter 7, that thing, OR versus EE. You guys did this, right? Okay. So words that end in OR is the word, some person that's giving whatever the root word is, and words that end in EE is the one that's receiving it. All right. Everybody here should have a will. It doesn't matter your age. You know, you're not invincible. We all have a time where we're going to have to face our mortality. Sometimes you don't because it happens so quick. Sometimes it happens in your sleep, but you're not invincible. We're all going to die at some point in time. So a holographic will is one that is completely handwritten and requires no witnesses. Why? Because it's hard for somebody to forge an entire document. It may be possible for them to forge your signature, but highly unlikely to forge an entire document, and that'd be easier to detect. So you could write a will right now if it's completely handwritten, requires no witnesses, and it's valid in the court of law in New Jersey. I get people that ask me, "Hey, what about video wills and recorded wills?" Nope, not legal. I checked with a class. I called an attorney while we were on the phone, while we were in class, and I asked him the question. He's like, "Nope, they're not legal." He's like, "If you want to, for dramatic purposes, you could make one of you reading your will, your written will, but that written will, you really need it in writing." And I guess today, with especially those AI generated videos, you should really have one, right? Under New Jersey estate planning law, holographic wills can be probated and will be served to ensure the testator's assets are bequeathed according to the testator's wishes. And dower and courtesy rights for real property acquired by married deceased person before May 28, 1980. Your surviving spouse is entitled to half of everything, no matter what provisions are made in the will. So, I think this is winding down to the final part of this chapter here. Yes, it is. Now, right now, we're at the time for dismissal. However, this will take me about 5 minutes to read through. Let me read through this, and I will show you how descent and distribution works. And then we'll be done with this chapter. So, title, transfer of title by descent. Title of real estate and personal property of a person who dies intestate passes to their heirs under the descent statutes. And the primary heirs of the deceased are their spouse, civil partner, or domestic partner, or close blood relatives. When children have been legally adopted, most states consider them to be heirs of the adopting parents, but not heirs of the ancestors of the adopting parents. So aunts and uncles and such, you're not really their blood relatives. I mean, if they wanted to, they could name you in a will to leave you stuff, but you can't lay claim to it and say, "I have a right to that. That is my uncle. So he died and didn't have a will, so I'm going to claim the estate." Well, excuse me, I'm dry. They said you're not entitled to that as a natural heir. Heirs can only be natural blood relatives, right? or your adopted parents. In most states, illegitimate, oh my God, that sounds so harsh. What is an illegitimate child? That means that your parents were not married when you were born. So if your parents were not married when you were born, you're entitled to inherit from your mother, but not your father. Even though we're talking about your real blood father relative here, you're not entitled to inherit from him unless he admitted to being your parent in writing or it's been established legally some other way, like with a blood test. If he legally adopts his real blood child, that child inherits like an adopted child would from the father, but not from his other relatives, which is weird because they're natural blood relatives. So it's kind of weird, isn't it? I told you some of these laws seem like they're kind of medieval, you know. Now, intestate real property is distributed according to the laws of the state, and these descent and distribution rules only apply if you die without a will. A surviving spouse or partner becomes the sole heir if the descendant leaves no parents or children. If there is a child or children who are also children of the surviving spouse, the spouse or partner receives the first $50,000 of the estate plus 1/2 of the remaining estate. The rest goes to the child or children. If the descendant leaves parents and a spouse but no children, the spouse or partner receives the first $50,000 plus 1/2 the estate. The rest goes to the parent or parents. If there are children who are not the children of the surviving spouse, we see this happening now. People get remarried and they already have children from other relationships and such. If there are children who are not the children of the surviving spouse, the spouse or partner receives half the estate, the children the other half. Where no spouse or partner survives, children become sole natural heirs. Where there is neither a surviving spouse nor children or children's own heirs, the estate first goes to parents and failing that to brothers and sisters or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins may be considered heirs. But beyond that point, the entire estate goes to the state of New Jersey by escheat. So what is escheat? The state treasurer sells the property at a public sale. They give notice by publicizing it in the newspaper in Trenton and the local major newspaper in the county where the property is located. The proceeds of that sale are held in a fund for 1 year, and if no claims are made within the year, the funds go to the state. They cheated you out of your property. Okay, so look up unclaimedproperty.nj.gov and see if you got any funds or properties that maybe they're due to you. Maybe you may be an heir, or you could lay claim to be an heir. Maybe you had an aunt or uncle or somebody, first cousin or somebody that died that you could lay a claim to that, right? Unclaimedproperty.nj.gov is where you go. All right, so that concludes chapter 17. Let's do the key terms to review. There are one of them, and then we're done with this chapter. Person named by the state to administer a descendant's will.
Administrator.
What is A? The administrator. Court proceeding to establish validity of a will. And to confirm who all the natural heirs are and people who are named in the will are who they say they are. To make sure all debts have been probates. 10 is B. All wills need to be probated. Title acquired by usage.
Adverse possession.
Yes, 2 is C, adverse possession. Person named in a will to administer a descendant's estate.
Devisee.
The person who you name in a will to make sure that all your assets are distributed according to your wishes in that will. Who's that trusted person that you're going to...
Executor.
They're an executor or if they're a female, they're an executrix. So right after executor slash executrix, EXECUTRIX, executrix. So executor or executrix. 5 is D. Transfer of title without the grantor's consent. Without their consent.
Involuntary alienation.
Yes, it would be. Involuntary alienation, 8 is E. Without having made a will. What do you call it when you die without a will?
Intestate.
7 is F, intestate. What do you call the person who makes a will?
Testate. No.
Yeah, you got it. That's right. Testator, but there's two versions, just like executor. There's testator, who's a man who made a will, and a testatrix, who's a female who made a will. And that's spelt test, T-E-S-T, the letter A, trix, T-R-I-X, testatrix. All right. So 12 was G. A document disposing of property after one's death. What document explains how you dispose of your property after you die?
Last will and testament.
Correct. 9 is H. Having made a will, if you did make a will and you died with a will.
Testate.
Testate. 11 is I. Acquiring of property by natural heirs.
Voluntary alienation.
Acquiring a property by natural heirs. You may not have had a will. We just read through the process that if you died without a will, who can lay claim to it? Who can inherit your stuff? Who is that natural heir?
Devisee.
Descent.
Okay.
Acquiring a property by natural heir is done by descent. We just read through the laws of descent and distribution of who can claim to be a natural heir to get your stuff. And there's blood relatives usually, right? So 3 is J. That's the difference between an heir and a devisee. A devisee is someone you named in a will to get your stuff. An heir, you don't even need a will. As long as they're a blood relative, they could claim your stuff because they're related to you by blood. Okay? So that's the difference there. 3 is J. One who receives real property through a will.
Devisee.
Devisee. 4 is K. One who can inherit the blood relatives. What do you call them?
Heir.
An heir. 6 is L. And transfer of title with the grantor's consent.
Voluntary alienation.
13 is M. There you go. Yeah, next to L, the letter L, at the end of that line, after it says one who can inherit, write blood relatives after that. Adopted children. Adopted children can inherit as well from their mother or their father, just not their ancestors. All right, so that concludes chapter 20. We're done for the day. So let me stop.